Welcome to our podcast, Hot Topics in the Workplace When Medical Conditions Flare Up. Thank you for coming to our seasonal finale. And with me is my co host, Felicia Amenta.
Welcome, everyone. Happy holidays.
Thank you so much, Felicia. You've been such a great partner for the last several years of doing this, and I'm pleased to announce that you're going to continue. And this is great. And so we might sprinkle up next year with a few guest speakers here and there, but we'll continue to deliver you the most in terms of our what we face, what we deal with, what we get questions from people just like you all the time. And so just to give you an idea of what we're going to talk about in this recording is remote hybrid work as an accommodation, not a default. And interesting, we've got a couple of cases that go both ways on this one. And then employee insistence on remote work when supervisory responsibilities require on-site interface. That's a real live case and very recent. So I've got some good updates for you on that. And then also the timeliness of the interactive process. And Felicia, I'm so glad you're going to weave us through some of the ins and outs on that one. And then we're going to also talk about tying into that inconsistent practices and poorly handled or documented, the pitfalls that can create for employees and employers. And then when medical documentation doesn't support observable behavioral performance issues. And I've had a couple of hot cases around those topics. So let's get going, Felicia.
Great. I'm ready to get started.
Okay, so let's talk about this whole remote hybrid work. It used to be, I think it was only like 12% of the work population that ever worked remote prior to COVID. And I've seen that happening for years. But of course, then we all went Zoom or Teams or whatever. And now we've been seeing the emergence back the other way. I know you've got some cases on that, so let's get started. Let's talk about that remote hybrid work as an accommodation, not a guaranteed.
I found a kind of an EEOC case on point with a twist, and it is an AON worker with ADHD. So this one involves a non-industrial disability and who filed a lawsuit over a request to work in person. It's a little bit twist on the normal. The employee claimed that she couldn't perform at an optimal level when she worked remotely due to her ADHD. We see so many cases, and I think you have an example in a little bit with a in-person worker who wanted to work remote. We see more requests for that accommodation. But Aon faced a lawsuit from this worker with ADHD who said she was fired after being promised the ability to work in the office full time. And it's interesting because she was an account specialist in a business that would usually lend itself to working remotely. And they told her she could work in the office full time when she was interviewed and hired to accommodate her ADHD disorder. But after she was hired, she was informed that her role was mostly remote and full time work in the office just wasn't possible, perhaps one day a week. And she emailed her manager saying that she was having trouble performing and learning her duties at home. And her manager told her, this job may not be a fit environment for you, and wrote her up and put her on a performance improvement plan. So over on the performance track, not on the accommodating a disability track. And then she filed a formal request for an accommodation. And that was approved by HR, and she had begun working back in the office, and then the manager fired her shortly thereafter. And she filed lawsuit under the ADA stating that she was experiencing discrimination and that she was fired because of her ADHD disability. And she claimed she was denied her accommodation request initially, and then she was retaliated against and fired because she asked for one. And so the Aon case is a twist because she felt she was discriminated against because she wanted to work in the office, not remotely. And the takeaway from the EEOC is that best practices for ADA compliance are the same, whether the person is requesting to work from the office to hybrid or hybrid, back to home, or in the office and back to home. They said the employer still has to engage in the IPM, which they did not do, to discuss why the accommodation was needed, what is the disability, what alternatives are possible, and if the request meets that undue hardship threshold. So it's very interesting because I looked at another case, Deborah, when I was
Mhm.
preparing for the podcast, because there was a jury award last year in 2024 against Wells Fargo. Same thing for denying an accommodation request to work remotely. They didn't hold an IPM, they didn't fully explore the issue. And the directive was that you can't work from home. This person needed access to a restroom on a very frequent basis because of his disability, and he was fired. And the judge determined that they failed to engage in a genuine discourse regarding the
Mhm.
disability, and the jury awarded $22.1 million against Wells Fargo. And that case was litigated. So it can be expensive, these
Yeah.
decisions not to fully explore. And I find the twist case with Aon so interesting because HR was trying to look at the formal request for accommodation, but the manager was writing her up, putting on her performance improvement plan, and then fired her. He was over on performance, right? Not performing
Mhm.
the job rather than working on with HR on the accommodation.
Yep, yep. And on a note on that, because I've had some very interesting situations, we'll tap into that a little bit later. But that it's not that you don't do the performance thing, it runs concurrently. But before you take any aggressive action like termination, you need to use the accommodation process to see if you can't elevate performance back to where it needs to be. And so that's where when you have knowledge of a medical condition and there are performance issues, then you use the interactive process to see how can we help raise this employee's performance, and might do a 30, 60, 90-day performance improvement plan as part of the accommodation process.
To help give them time. And I love
Yes.
the EEOC's guidance. They always at the end of these cases give you a what not to do, what to do. They said
Mhm.
employers should keep in mind that while allowing an employee to change work locations, meaning to go from the office home or home to the office, that can be a reasonable accommodation. They might have to modify a work rule or a policy for this to
Mhm.
happen. And I'll talk about that in another case later on in our.
Yeah. Yeah, great. Yeah, and the one that I wanted to bring up is it actually was a more local case. So I'm not going to say the employer, but it basically determined where the employer was found to be lawfully or in their lawful right to deny a request for remote work as an accommodation. And why? Is because the employee could not provide documentation to support that he had a medical condition that required remote work. Okay. And so that goes back to, we keep saying this, medical documentation drives this process. And in this employee's case, he said he had a condition and that he needed to work remote. Okay. But he never could produce any medical documentation that actually identified the necessity to work remotely. And that was upheld both at the EEO level and in FEHA. Both of them say you have to have medical documentation to support that need, just not just because the employee wants it. And that's why I wanted to, it's not a default.
Right.
And this is where a lot of employers are going also, is that remote work should be evaluated on a case by case basis unless the job is already designed to be remote. There's, like I said, I've seen remote work for years, but as an accommodation, and that ties into our second point here, is this was actually a pregnancy related accommodation for remote work because of postpartum depression. She was able to work, but could not handle being away from her newborn baby. Now, the thing is, this has been going on for a while. She was a director, actually, not just the supervisor, but a director in charge of programs and a number of employees, both student employees and regular classified employees. And she was insistent that she needed continued remote work. Some problems had happened over the fall, in that had she been there to timely take care of things, that would have probably been handled in a more appropriate manner. Instead, because the proper people of authority were not present, i.e. her, lesser or lower level supervisors took action, which led to some very, I can't say costly, but costly emotionally and legally. Police actually got called in, and because of a supervisor overreacting to an employee situation. And so again, it was perceived that there was a lack of oversight because she couldn't be managing those things on a remote basis. And what was also interesting in that case is that part of her request to continue the remote work is that she was planning to go back to school in an online program. So it's okay, if you're supposed to be home for postpartum depression, then working and going to school, and how does that fit in? But that's a whole nother judgment call, and I'm not going to go there, but it just raised a lot of red flags as to the appropriateness and validity of this. And she wasn't very cooperative in getting updated medical information to support the ongoing remote accommodation. And quite honestly, she's been put on leave. So yeah. Yeah. So
That was the way that they did the accommodation. The interesting thing I thought about the Aon case with a twist, because she wanted to come into the office, which they
yeah.
were like, no, you can't come back into the office. And I thought you and I would not, they had a big office, that wouldn't have been such a difficult thing to do, maybe to see if that was possible. She initially did not provide medical documentation of her disability, but when she made the formal request, the medical documentation was there.
Okay.
And they still
Okay.
didn't meet, didn't interact.
Yeah.
When she initially asked for it, didn't interact. And when she formally asked for it, didn't interact. So,
Yeah, yeah. So I think to sum up these first 2 points, Felicia, is that again, the critical importance of having that interactive process, engaging with the employee, not just making decisions without having a conversation. And then also ensuring that you have appropriate supportive medical documentation. Request for remote work just isn't automatically granted. It's got to be supported by the laws for accommodation. And then also, in these cases, requests for remote work or coming back to work really need to be evaluated on a case-by-case basis too. And again, while the medical condition may warrant remote work, again, like in higher level director, administrative kinds of positions, part of the essential functions is to be engaged with employees and attend meetings and not just remotely. And you have to take a look at the business need and the business case. So remember, it's always a balance between what does the employee need, but also what does the employer need, and to weigh that out. So that sort of takes care of these first 2 points. Yeah. And then timeliness, that sort of rolls right into this one too. Timeliness of the interactive process. And I know you've got a few things to say about that, Felicia. So go ahead.
yeah, the time is short. And in workers' comp, not for non-industrial disabilities, but I always tell the employers, try to think that you're on a short track, right? The track is short. And I don't care if it's non-industrial or if it's industrial. This is really it moves it to the top of the priority pile because the lawsuits and there could be big penalties and fines. In workers' comp, the 60-day clock from the date from your insurance company or your third-party administrator, in our case, Athens, receives the doctor's report. It's not the date the doctor wrote the report. It's the date that they timestamp it in that received. Then they, from a time management standpoint, need to send just the work restrictions from that report as soon as possible over to the employer so they can start the clock ticking and the process. And I always, at the very beginning, say, how much time do we have? When does the 60 days run out? Because we have to do a lot of things, right? We have to schedule a meeting. We have to offer them the ability to bring in family, to bring in union reps. So other people need to come to the meeting. We need to schedule a meeting. Sometimes we're in holiday break time, like now, where we've had holidays and times off. And you have to be cognizant and aware of that because some people are traveling. And that 60 days can just go by in the blink of an eye. And there's also a conversation usually between the claims examiner on the comp claim and the employer. Do you want to hold the interactive process meeting, which you need to hold now with these permanent work restrictions, by yourself with the employee, and then we'll just leave you to the time frame. What we need back from you is either we met and in the 60 days, we've either made a letter offer of return to work or we've made a decision. We're so sorry, we're not going to be able to accommodate, and you're going to need to pay the work comp voucher. And they need to know that, right? In the 60 days. And we have just had so many employers with so much stress around this time. So I think if you're going to manage the process yourself versus using a mediator such as yourself to do it, you'll keep track of the timelines for them. If you're going to do it yourself, you have got to keep track of the timelines. You can't let the time get away from you and then you just don't get back to Athens. You might have to pay for a $6,000 work comp retraining voucher, and you've made a decision you're going to take the person back to work because you just haven't had a chance to have the meeting and get all of your documentation done and ready. And that is unfortunate, right? You don't want to have that happen. And conversely, on the non-industrial side, I still think you're on a hurry up. If there's no 60 days, you need to be acting in a efficient manner to try to reach out. And I always tell them like 2 to 3 weeks. You get the work restrictions in 2 to 3 weeks. You should be working on setting up a meeting and following that rule of threes that we've talked about with some of the civil panel attorneys of scheduling a meeting. If they start resisting, they don't want to come, they can't get their union rep, schedule a second meeting. If they say we can't come to that, my sister can't come, my family can't come, my husband can't come, schedule a third meeting. And then if they keep resisting, we're going to hold the meeting without you. We don't want to do that. And then I think you have great resources that you're going to talk about that you can that they can send to their employees to help them also.
Yes, absolutely. Now, I will acknowledge, Alicia, that while the ADA and FEHA don't have a rigid, how do I say this? Let me restate this. Workers' comp, a decision must be made in 60 days. And if you don't, then the consequence, shall we say, is that you have to pay the $6,000 in retraining, whether or not the employee continues working. Okay. The thing is that ADA and BHA also have a 60-day timeline. Once you know of maximum medical improvement, then you need to be able to make that decision in a timely basis. Now, there's no real consequence like workers' comp, like the $6,000. However, again, if the case were to go to litigation,
Yes.
then yes, the employer could be fined for failure to engage in a timely manner. And that sort of ties in a little bit in terms of inconsistent practices and poorly handled. That case, and I'll come back to that, but that case also addresses the untimeliness that employers may have engaged. And so there have been court cases at the EEO and BHA levels that will ding them if the case were to. Yeah. One of the things I'm sure many of our viewers and listeners have heard me say before is that I advocate, and this is based on my 35 years plus of working under the ADA and FEHA, is because again, they don't, when you have knowledge, I'll just go back to that. When you have knowledge of an employee's condition, that's really the best time to get the employee engaged so that they're educated and informed. And when you do that early initiation, you find employees will be less resistant and less non-cooperative, or on the other way, they're more cooperative and they're less resistant when you have that early intervention because now they know. And so even if you don't have the IPM early because you may have to do it again, once you do have maximum medical improvement and long-term limitations, work-related or not, I would still encourage all of our viewers and listeners to use my free resources at my webpage. Again, relationships-work.com/tip, TIP /. And we have it both in English and Spanish. And so you click in the upper right-hand corner to select your language. But we have a whole narrative that brings in all of the laws. And then I have a 10-minute video also in English with Spanish subtitles that people can view. And I find that when employers have shared that resource with people, again, they're far more receptive to engaging in the interactive process when we have to have it. They at least have met me if I'm going to be facilitating the IPM, so I'm not the stranger, who are you kind of thing. And I take less time in having to explain my role because they've already seen it. But this is something you can share with employees early on and just say at some point we may be initiating this, but it may be premature now. Something as simple as that. But here's to let you know about this whole process that most people don't know about until you have a medical condition.
And we have a case, and I won't mention the employer, that I know you've been working on for a while now. And it's so interesting because I got a call over the weekend, and there's been several IPMs. I want to say there's been 2 or 3 different IPMs with offers made, but there's been medical documentation back and forth and changes with doctor's appointments. And they said the employee wants to meet again, and the employee refuses to sign the letter offer of return to work that's based on the medical documentation that we have, because now he's saying he's got new medical documentation that changes the work restrictions. And I said, great, meet again. They were like, how many times do we need to meet? I said, however many times you need to meet. Don't ever say you're not meeting, or you don't want to meet, or we've already met, or there's nothing more to talk about. Because if he has new notes, great, Let's take a look at the new notes. Does it change anything materially? Maybe not. Here's still your letter offer. You need to sign it. You're out of work until you sign it. You're out on sick leave until you sign it. When you want to sign it, you can come back to work. And there's been so much back and forth. But I told them anytime the question is, could we meet again? The answer is always yes. Why wouldn't you want to have more dialogue? They were like, "There's nothing new to talk about." And I said, if the employee feels there's something new to talk about, maybe there is. Now, maybe you'll meet in there and you'll take a look at the note, you'll talk about the note, and you'll say there's no material change. We still have made the offer. We still feel we can accommodate this. You need to sign the letter offer of return to work. It's very interesting in that case because they have made an offer of permanent modified work. Employee won't sign it. In their policy, you need to sign the letter offer of return to work and accept it formally, or you're not coming back to work. And then there's the Alamo. They're at a standoff.
Yeah.
And I have to say, I have never seen this before. This is new in my 45 years. Most employees want to come back to work, but they haven't been able to work out the whole process. It's interesting.
Yeah, very interesting. And I know we've spoken about the situation before and that we're getting ready to hold another IPM. Yeah.
And
So I want to build on, because when we talk about these timeliness or lack of timeliness, there was a recent Fifth Circuit decision that found a 6-month delay in granting an accommodation request. When I say granting, even addressing an accommodation request could itself amount to a failure to accommodate, failure to engage. And that that's slow walking the process is now a litigation risk, not just a best practice failure. And yeah, so we'll have that in our show notes. But again, the failure to engage or the failure to do it so timely now could be your litigation, which goes back to what we were talking about a little earlier too. Yeah.
And whether you manage risk or whether you manage HR or wherever you manage these return to work issues, because they're handled in different departments at different employers, I feel these issues, these return to work issues that we talk about are so expensive. When I look at the EEOC cases, they need to go on the top of the pile of things to do. Meet with that disabled employee trumps a lot of other things. It's really important. And those can't go on the back burner. You can't forget about those people. Those are the things that I take calls on the cell phone about all the time, right? Because they need to be addressed timely. And when is timely? You and I, that's an interpretation for a reasonable person. 6 months is definitely not timely, right?
No, that's happy here. That's for sure. Yeah. Yeah. No, I want to share something about these inconsistent practices because we've been talking about this throughout our topics today. And I just thought, again, there's been some new cases. And so in August, just this year, there was a school district further north that the California Civil Rights Department reached a settlement with because there was alleged discrimination, disability discrimination in terms of handling an employee's request that actually resulted in a $90,000 payment and required them to do policy updates as well as training and monitoring. And so this is a case where, I've seen this many times before at the EEOC level where if there's discrimination of any kind, for example, and it's found to be substantiated, then the EEOC may require that an organization engage in certain kinds of training for all of its employees, particularly the supervisors and managers. There may be fines, the whole host of things. But this case is actually at the California level. And so this is just to show you, to show all of our viewers and listeners that you may be required to do things you might not normally do. And so in this case, the takeaway for our school districts out there is that make sure that you have a centralized accommodation process practice so that you don't have the left hand not knowing what the right hand is doing. And that's why it's so important, particularly in school settings, that principals or assistant principals refrain from doing accommodations without involving HR, because that's where we've seen a lot of inappropriate, lengthy, now I'll go back to inappropriate again, where accommodations were made that are not consistent with accommodation practices, like having somebody else continue to do some portion of their essential functions, for example, and also training. And this is where I know that over my years of doing this, that several school sites have brought me in to provide training to their managers from different departments so that they know better what to do when these issues come up at the site level, and to make sure that they know to get it to HR. It's just too risky. It's too costly to go on your own. And that's why it's so important to involve HR and risk management. So again, court cases are out there and $90,000 isn't something to sneeze at. And on
Mhm.
top of that, they also had to do all the training, revise your policy. Like you were saying earlier, they have to revise your policy and so forth. It really is time to take a look at just how do we do this? And I know I'm Gail with a school district who the people who did it before are not there. And
Mhm.
so the high level people, they really don't know what this process is all about. And so I'm educating them about what to do next and so forth. I know other school districts have been, okay, no, we don't have a policy around temporary accommodation, how long it
Mhm.
should be. And that's part of that other case we're talking about. A temporary accommodation went on way too long.
And you're right. One of the employers that we work with, one of the school districts, they had in their written policy 30 days. We only accommodate disabilities for 30 days. That's very short. It's the shortest that I've ever seen
Yeah.
from anyone, but that was their written policy. But they accommodated people for over a year. So the policy wasn't being adhered to anyway.
Yeah.
And so I said, you need to relook at that. 30, I don't know any other district or any other employer for that matter that only has 30 days. That's not enough to recover from anything, non-industrial or industrial. That's pretty major. That's pretty severe. And I said, more of our districts are going to a more liberal policy with more time than less. And I've seen 90, 60 plus 60 to 120 is real common. And then we had one that went to 90 plus 90 to 180. And that was working. They bargained that with the union, right? Because they felt like they needed more time to recover. And the case that I found talking about this poorly handled and documented, it did have to do with a company policy. And I looked at about 6 recent lawsuits alleging ADA violations that have been filed like just in this year in 2025. And this particular one was an employer's actual written policy violated the ADA. It's a train conductor for Union Pacific Railroad. He dislocated his shoulder. He had physical therapy, he had treatment, and after his treatment, his doctor released him to return to work with no work restrictions. And this is a medical documentation. The employer did not get their own medical evaluation or do a fit for duty. They refused to allow him to return to work due to concerns that he might re-injure his shoulder and climbing ladders, which is something they have to do at the railroads to get on the trains. It's an essential function of his job. So per the company rule, there was they didn't allow any working in safety sensitive jobs if there was a 1% chance of re-injury. And so they kept the employee off work. 1% chance of re-injury, what is that? That's everything, anything, right? And
Anybody.
so the employee sued. He sued for discrimination, he sued for back pay, he sued for current pay, future pay. And under the ADA, and this is an Oregon case, this was filed in Oregon, and Oregon also has some state laws surrounding return to work. And he was awarded, this case already has gone through litigation. He was awarded $952,863 in back pay and future pay, $1 million in further damages, and 25 million in punitive damages. And then the comment was that they needed to change the written policy. There is that written policy that you can't be even 1% disabled or you can't return to work. That's not there's no medical substantiation for that. And many people can work that are much more disabled than 1%. They had to go in and change their written policy because their actual policy was in violation of the ADA after this huge case. And this was very poorly handled, right? As they didn't meet with him, they didn't interact, and he didn't have any medical work restrictions, right? They determined that because of the injury that he had and the treatment that he underwent, I don't know what if they're not doctors, that they overrode his doctor and made a decision to keep him off work. So I thought that case was fascinating.
Yes, absolutely. And particularly to hear about all the different levels of damages that were awarded, because that's something to be aware of too. It's not just like the $6,000 in workers' comp for you don't make your decision, but you do get into lost wages, future wages, punitive damages. And it sounds definitely that employer clearly had a mindset, an attitude, a judgment of bias about people with medical conditions. And the reality, like you said, 1% is nothing. People have all kinds of conditions all the time and still continue to work fully or with minor modifications. So just the fact that a disability exists or a medical condition exists does not warrant taking somebody off of work. It's got, again, what's the medical documentation to
Mhm.
substantiate limitations or not? And even then, can accommodations be made? So
Right.
that one is really reflective of attitudinal bias.
Yes, as I said, the whole policy shows a pervasive disability discrimination kind of company-wide to have
Right.
a written policy. By that, it shows your bias right away. And the one thing I was talking with a school district the other day, and they said, oh, so there's no damages and there's no punitive for making decisions about whether or not we can accommodate or not, or bring somebody back or not after a comp claim. And I said, not in workers' comp, but certainly on the civil side, there is. And it is so much more expensive that our little $6,000 retraining for the failure to offer them is nothing, because that's not where that litigation will happen, is not
Yeah.
in workers' comp. That's why I get so many calls, and you get so many calls and so many good emails with questions on this subject, because I consider it sensitive and so careful. I always tell them, step slowly, check with people before you make a decision, make sure that you're doing the best thing for the employee and for the employer.
Yes, absolutely. Absolutely. Yes. We have one final topic that I want to bring up. It really touches on several areas. Both are non-work related medical conditions, both involve performance issues, and then the observations of performance are not substantiated by medical documentation. And so it's very, I have two. And so the other point is that they both involve teachers, and then the question of fitness for duty. And we're probably more familiar with fitness for duty for classified, but the rules are very different under the ed code for teachers.
Yes.
And so both of these teachers have been long-term employees in the elementary school level, but both involve demonstration of highly inappropriate behaviors in the classroom, and in one case, outside of the classroom, but directed towards coworkers and the site administrator. And so it was, particularly in the second case, the first case, the employee was actually taken off of work for performance-based issues. And it was only this year, coming back to school, they've been working with her around the performance issues. But it was only this year, coming back to school, that she disclosed that she does have an existing medical condition that not work-related, and it is progressive in nature. And so they've been seeing the progression of the manifestations of the disability. And again, and parent complaints, student complaints, they moved her around to see if there's a better fit. The quality of teaching is not to where it is. It's become very rote, and lack of imagination and creativity, and not engaging students appropriately. And she actually wants to be put back to where she was previously, but that's where she started demonstrating so many problems. And so we've been having difficulty getting response from her doctor. Then it was actually a nurse practitioner that responded to the cognitive and behavioral capacities form, did not respond to my letter and customized questionnaire that really addressed the condition. And so we're still struggling with. And the employee was provided, I consulted closely with Job Accommodation Network as far as what do you do in a situation like this. So she was placed in a temporary support position. And yet the board wants to take action to terminate. So you got to do due course. Got to do your due course. And so then, like we said, we got one questionnaire completed, and it says she can do all of her job fine. It's like, that's clearly not the case. I've done my
Yeah, and is that her piece? That's from her PCP. Yeah, so that's what
Yeah.
she asked them to write. And it's such a tough thing, because a fit for duty physician has such a different role than a PCP does. PCP should also be doing what's safe and what's best, but they usually will write whatever their patient asks them to write. They really will. They don't want them to lose their job, and they really don't know anything about return to work, non-industrially, or the ADA or EEOC. They'll just do what they usually write, whatever they ask them. Not always, but it's you and I see it all the time. A fit for duty is they're in a different role. They're going to see them once, they're going to review their records, they're going to see the job description, which sometimes the PCP doesn't even look at, and make a decision whether they can work in their current job, whether they need to work with work restrictions, or whether they can't work anymore. Right, because of what it is. But you're right, with the teachers' rules and the ed code, it's rough, especially if it's mental health. If you're
Yes.
in that psychology, psychiatry world, the
Mhm.
battle, the struggle is real, right?
Yeah. 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 And so this first case was talking about was also complicated because she gave us the name of her treating neurologist for her condition, but and from a certain center. And then the questionnaire that we did get back from the nurse practitioner was from a different agency. And we have no way of knowing, does she even treat this person for the problem, the condition?
Mm,
Or who is this person? So she hasn't, but she's actually still been working the temporary position. But so now the employer wants to do a fitness for duty. I said, you better talk to your legal counsel because under the ed code for teachers, if it's got anything to do with mental health, there are cognitive issues, but she has had emotional outbursts, not treated students very well, that the ed code requires a panel of 3 psychiatrists or psychologists to be involved. So then it's getting agreement with everybody. It's not just something you can do like you do for a classified employee.
more
And
like
that's
a agreed medical examiner in comp. It's like the parties have to agree on a psychologist or a psychiatrist to make that determination because the union is very aware that process can say that they cannot return to work. And with a
right.
certificated teacher, that could end your career. But what I
Right.
do see and what you see a lot is they'll put them in a supporting another teacher or maybe a program position while
Right.
they're working through this issue.
And that's exactly what happened in the first case. Now, the second case is a little bit different in that we actually done an IPM for a different medical condition 3 years ago. But one of the issues was a significantly high rate of absenteeism. I'm talking like sometimes 54% absenteeism rate,
Wow.
clearly over
Mhm.
50% threshold. And last year it actually got better, but now this year she's already, I can't remember the number, but the teacher's already been out excessively in just the first 3 months of school. But then she started making some very inappropriate remarks. She started posting things on social media board that the teachers share at the
Mm.
school. And sorry, just a- and so it was like, okay, what's going on here? And so what was found, I apologize for that. What was found is that again, she was given the employer wanted to send her for fitness for duty right away. And I actually had somebody identified and it was like, oh yeah, that's right. We can't just do that.
Can't just pick some.
And so the employee went to her doctor, the doctor cleared her to come back to work. And
Yeah.
so we had a follow-up IPM and said, okay, since there is no medical condition supporting your absenteeism, supporting this outburst of inappropriate behavior, the public postings, et cetera, these are all now performance issues. And so if absenteeism continues or any other inappropriate displays of behavior happen, because there was some stuff like I said, inside the classroom, outside the classroom, this is strictly performance then. And so the union was involved and so, but that's the course that we have to follow. If we think there's medical, then we need to do it properly, but then we need to bring it close to the interactive process if there's nothing medical to support. And that sort of ties back to our first case.
Mhm.
So give remote work on someone's request. And
Right.
if there's medical documentation, in this case, if there's no medical documentation, and now she's cleared to work, then it goes strictly back to performance.
And I get the question that you get a lot too. If they feel like the observed behavior that they're seeing is that there's either neurological or cognitive or mental health. They don't always know what the problem is, but they can no longer function in a classroom from the observable behavior. And this is from the principal and the administration standpoint. And then they talk about, can we terminate? And I'm like, okay, we're so not there. That's when you have to involve your advisory council, your employment law attorney that you use for these matters. And now we're stepping very carefully because, again, you have no medical documentation of what the observable behavior or cause. So you have a lot of steps to go because there's, okay, this is just isn't working out. They can't perform the essential functions. Can we just start the termination process? And because of those ed code rules about even who you can use, right?
Yeah.
It's going to take a long time, right?
Yes. Yes. Unfortunately, it's not a short process, but again, there's a lot at stake for both the employee and the employer. And we shared a number of cases today. I'm talking about the significant costs when not done right, not timely, inconsistent practices, medical documentation not supporting the request for accommodation or the support for inappropriate behaviors. So it all goes back to the medical. But again,
Right.
following
And
the
the only different answer I give, I would say, is when there's harm being done. You and I have both seen cases, unfortunately, where there was some issues with students where harm is being done. And that's different than we're talking about paid admin leave for a
Mhm.
certificated teacher. And then we're talking about trying to get an agreement to a fit for duty and that they are not going to work, but they're being paid not to work while that process is going on, because those issues are clearly different because of the great liability they have for the children that were served.
Right. And that's where we talk about direct threat against the safety of the
Right.
employee as well as the safety of others. And
Mm.
that's where we've gone into where it's the safety of others that is
Mm.
problematic. Yes,
Right.
yes. Felicia, this has been a really rich podcast today with lots of very important topics with where we have both local cases as well as court cases to substantiate some of these concerns and issues. And there's one word to say, it's be proactive.
Don't sit back. Don't wait for, somebody said to me the other day, we're waiting for them to bring us something. And I said, no, we're not waiting for them to bring us anything. We're
Yeah.
proceeding with scheduling the meeting. We already have a note. We have enough that we can proceed now. They say they need to bring in some more things and they're looking for it. No, all of this is wasting time.
Yeah, yeah. And again, I go back to if you have knowledge that, either again, a medical an employee has said something to somebody. We've seen a lot of those cases where, yeah, they're saying that they have a medical condition, but they haven't brought anything in. Initiate the interactive process, educate the employee about what's required on their part in order to be accommodated. Again, they don't know about the accommodation process or what's involved. Some do, many don't. And so the interactive process is just a great way of engaging the employee and covering your bases legally while also working towards accommodation. Felicia, we're bringing a wrap to our 2025 season. Happy holidays to all. And I'm very proud to announce that Felicia, although she's resigning from her position at the County Office of Education JPA program, she is continuing given her significant knowledge, and you'll see her back. Felicia?
Yes, I'm happy to help or be a guest on the podcast even after I am retired from my position at the San Diego County office.
Okay, so that's good news, and I'm looking forward to 2026 with you.
Oh, wonderful. Me too.
Okay, thank you, everyone, and happy holidays to you, and we hope you enjoy this. Let us know. We don't do this just for fun, but we hope to educate and share and inform you about how to handle conditions, medical conditions in the workplace.
Yes, happy holidays to you and yours.
Okay, take care. Thank you so much, everyone. Bye-bye.
Bye, everyone.